This was a motion that was set for 2 weeks ago. Mr. Libet became quite upset. I told him we were going to have to re-notice this for an appropriate time this week. Everybody's here on this matter. Well, Ms. Brower he maintains clearly that he was in prison at the time of conception. And so clearly he was not. I think this was a default judgment.
Yes. Your Honor, I do have a question. I'm just curious. So the defendant was served with a complaint on October 9th, 2019, while he was in the Newaygo County Jail. Our judgment and UCSO were entered on December 5th, 2019. My question is, why did it take him almost 5 years to file this motion?
Because he's mad and bitter and he's trying to be petty. That's why. But we could do the DNA test, and we ain't even got to do all the extra stuff. I could do the DNA test today or whenever y'all want me to do it. He's just mad because he got a boy my girlfriend.
Well, it sounds like he was incarcerated at the time. Ms. Brower.
Me and him went down there together. Y'all
Stop
can
a
find,
minute. Stop. I'm talking to Ms. Brower. He indicated that he'd done mostly for quite like 8 years or something, as I recall, has been in and out of jails and prisons, and said, I don't have any, because I said, look, I get a lot of stuff filed from prison. All right. Why did you do it? He said, I didn't have family or anything to try and help me.
Okay.
If he didn't, I don't want to make him father of a child if he clearly is not, especially in adult. So
I understand. It was more so just a matter of curiosity.
Yeah,
why
I was
that
too.
delay? Yeah.
And that's how we got into a battle.
Okay.
Libet and I had words. But I mean, I want to, if he's not the father, I'd like, Mr. Libet, are you there?
Yeah.
All right. I'm going to order a DNA test, which means you'll get information on where to do that. And if it comes back that you're not, I will, I'm certain we'll find that we'll revoke the paternity. But at this point, I need you to cooperate. The prosecutor will facilitate a DNA test because I have to order that. Okay. And once that's done and completed, we'll come back and see how things go. All right.
Okay. So is y'all gonna write me and stuff? This is a nausea because I never even got no message about this. I'm getting a text message from my phone talking about court. Like I'm not even getting nothing to my house, like no paper or anything.
Look at your. I'm not going to read your address because we're on the on YouTube. But is it just?
Yeah, it's the same address. Y'all got the right
3295.
address.
Is it 3295?
No, 4192.
No. You can email or call my clerk.
Okay, I will.
And Nazier, you will
Yes.
make sure that our office has your correct address too. So at some point today, if you could give us a call with the address, I'd greatly appreciate it.
Okay, I will.
Make sure if you go through Miss Brower, if you get her contact, please contact Tracy here. Okay. And we'll do the same. Man, we're going to get the information to you, but you got to make sure we have the correct address. All right. And because we're on YouTube, I don't really want to have you give it over the internet here. Okay.
Yeah, I'm not. I'm going to call and give it to you guys.
All right. It would be, you'd call Tracy Dewey here. I can give your phone number.
Yeah.
Can you? Okay. I'm ready for it.
It's 632.
104. Okay. I'll call after this.
And Mr. Libet, we'll get stuff out to you. I'm not going to read you're in Kalamazoo, right?
Yeah.
All right. We'll get that information. Please cooperate with getting the DNA test. We'll get to the bottom of it here quite quickly. All right.
Okay. Thank you.
Okay.
All right. Mr. Libet, you understand?
Yeah.
All right. We'll get you the information. Thank you all very much for it.
Thank you, Your Honor. I'll prepare the order.
Thank you. Versus Boynton. Both parties are present. Miss McCallum is here on behalf of the plaintiff, Miss Boynton. This was a motion filed by the father to enforce a judgment of divorce, in essence saying that she's not paying her fair share in the judgment of divorce of the 40 and 60% and whatnot. I do have a response. I'm not sure. Is there anything you want to add to this briefly?
So the one thing that I didn't bring up in my response is I had purchased a car for our daughter and had been making payments for the car payment as well as insurance and registration. Part of that agreement was that she would pick up our son's car and do the same because it was essentially a wash.
Is it in the judgment somewhere?
No, it is not.
I can't enforce stuff that's not an order.
Okay. I just want to make that noted because that has been brought against me.
And I'm also, I mean, things are not in this order also, like cell phone. You're claiming cell phone stuff, and there's nothing in here that says any percentage be done. A winter coat for Alex, that's not in here as far as I can tell. It's only for extracurricular activities.
I guess I was confused as to what that definition of was.
What, extracurricular activities?
Yeah.
Well, I'm not confused. I mean, to me, that means school extracurricular activities.
Okay.
So Ms. McCallum, anything you want to add?
No, Your Honor. I think we pointed out in our response that the request for reimbursement exceeded the extent of the language in the judgment, which was limited to extracurricular activities. And actually, it does also include the car insurance payments and vehicle maintenance. I do believe my client was contributing to the payments on the daughter's vehicle, who is now 18 at this point. So any payments moving forward are not covered by the judgment anymore. She is graduating.
My reading of it is there's anything after she turns 18 is not covered.
Correct.
But bottom line is here, if you guys have problems about, first of all, sir, if it's medical, all right?
Okay. She's
not paying that. That is enforced through the front of the court. That's the first process you do. They have a medical enforcement. They have certain timeframes you got to get it there. I'm not going to deal with the medical part. At this point, you will file that through the front of the court. If you're too late, you might have lost it, but there is a clear way to enforce it. As far as the other things that are in dispute, if these parties think that, she hasn't paid for some of the extracurricular stuff that is in here and you claim that she's done other things, I'll set up a 1 hour evidentiary hearing. People can bring in their stuff and we'll fight it out. But I'm not going to do the medical, and I am going to tell you, sir, the things like the cell phone and stuff, I'm not going to have in this hearing. It's only going to be related to who's paid for what that's in the judgment, which states 60% related to extracurricular activities and equipment and vehicle rated expenses, including but not limited to car and insurance payments and vehicle maintenance. Those are the only things that are up.
Okay.
All right. And we'll send out notice to you for just an hour that you're going to be in here. If you think there are things that are missing or haven't been, and counsel, you'll be able to come in and say, wait a minute, she paid this, and you guys need to exchange the stuff and figure it out.
Your Honor, could I request that we be ordered to mediation in the meantime to try and work out some of these issues outside of court? I really think that would be helpful in this case, and hopefully that would avoid an eventual evidentiary hearing if we are able to reach resolution.
It'd be a nice thing to do, because you could all take all your documents in there and try and mediate that. Have you guys had a mediator involved in your case before?
No, sir.
No.
Who do you think we should go to for mediation? Well, I can order mediation. We can do the dispute resolution center or something like that.
What if I know that Jane Dykema has been available pretty regularly for mediation. I would propose that we use her.
I don't have a problem with Jane Dykema. However, my thought is, when you propose somebody, Mr. is going to go, oh, how do I know that they aren't really, I'll tell you that Jane Dykema is fine. Mary Benedict's fine. I mean, there are a number. Mike Dantema is fine. I'm just throwing names out. I have no connection with any of them other than I see their work and they're able to mediate. Sir, do you have a problem with mediation?
No, I do not.
Any problem with Jane Dykema? I mean, I don't even know if she's available.
No idea who she is. So,
all right. Well, she's practiced a long time in family law and can get to the bottom of things. If you want to put in Jane Dykema, that's fine, unless she's not available promptly, and then propose. So you can look up Jane Dykema on the website and see, and if there's something that you really oppose, fine. But let's just get it done. Well, we won't set this 1 hour hearing until I hear from you that we have not been able to settle it through mediation.
Okay.
All right. Mediation, and then hopefully I don't see you again on this, but if I do, I do.
Okay.
Good
Thank
luck.
you.
Thank you. And motion filed by the father, in this case to exclude a third party, Mr. Walker, from being around his kids. It's a lot of things that he's had criminal background and counsel. I'm gonna tell you right now, even before I got the response, I mean, there's nothing of substance past about 2009 other than a driving offense. And I mean, the fact that he back in 2008 or something had some drug offenses is not, doesn't impress me at all. So you can go ahead, and if you want to add anything, counsel, you may do so on behalf of the defendant.
I understand, Your Honor, and I will focus then the information that I provide to the court on what we don't know and what plaintiff's response has failed to provide to the court. But first, my client wants to impress upon the court that his motion was filed strictly to protect the party's 3 very young children from potential harm and for no other reason. Plaintiff's assertion that because he waited after he first had concerns, there is somehow no risk to the children or merit to his pleading is not an argument at all. It's a deflection. My client waited because he was assured by plaintiff that she ended the relationship, and he filed after plaintiff and Mr. Walker later went Facebook official with their reconciliation in mid-July of this year. I'll simply state what we don't know about Mr. Walker and what's missing from that response, as I mentioned. We don't know if Mr. Walker has maintained his sobriety, and probably the most significant.
You never will, and you don't have necessary. This is her new boyfriend or whatever. Okay, you don't get to drug test him, or I mean, how's he supposed to show he is or isn't? I mean, it's up to the mother to make sure that the children are protected. And if he's drunk and causing a problem, and I don't have any of that in the pleadings anywhere.
I understand, Your Honor. But part of the problem here is that Mr. Walker's parenting time in Ottawa County is supervised with his own child because he's failed to verify even what they've specifically asked for of him. And if he has to be supervised with his own child, he shouldn't be left alone with Mr. Grable.
All right. What else do you have?
We don't know if the evaluation that was alluded to in plaintiff's response as completed last month has actually been completed, or that despite plaintiff's many exhibits, it's clear there's no exhibit verifying he ever submitted to one, and no licensed professional is even named by plaintiff in her response, and nothing has been provided by his treating psychiatrist to indicate those things that Ottawa County has been asking for approximately 3 years. And finally, we also don't know, as there is no sworn signed statement provided by plaintiff, that Mr. Walker has actually exercised unsupervised parenting time with his own child, despite a text exhibit that suggests he might have. He's been asked to provide proofs related to all of that in his own case and hasn't. Here, plaintiff has provided zero proof on his behalf too, likely because he hasn't or can't provide it to her, which appears to be his pattern. That's all I have, Your Honor.
Okay, well, all right, counsel, Ms. Johnson.
Just very briefly, defendant bears the burden here. So pointing at all the things that they don't know, that's not a shortcoming on plaintiff. They've not highlighted a single instance in which Mr. Walker has allegedly put these children in harm. It's all of this, it could potentially happen. And as you referenced, it would be mother's responsibility to step in and prevent that. Mr. Walker is not a threat to these kids. These kids have known him and come to love him over the course of the last year. It is false that defendant did not know that they were together. We have text messages from March. We have text messages from November. We have text messages from July.
We have some inappropriate text messages also. I mean, go ahead. I mean,
I don't think plaintiff has met, the defendant has not met his burden to exclude this individual from the children's lives. There's no evidence of harm. So to state that it is the plaintiff's burden to prove a negative, they haven't provided anything that would indicate that there's a current threat.
all right, thank you. Well, first and foremost, obviously, Ms. Grable has moved on as another person, and I'm not going to micromanage that relationship. These parties are divorced. They're both going to go their own ways, and I'm not going to sit here and try and figure out if the other's significant other. I'm just not going to do it. If you can point to me some harm that the kids have suffered as a result of him, certainly, and not only would I prevent it from continuing, but Ms. Grable would have to answer for it, probably in a motion to change parenting time or custody or something like that. I mean, she's the one responsible to make sure the kids are safe. And if there becomes domestic violence and the police are called and this kind of stuff, that's stuff that goes into possible change of circumstance, proper cause to look at change of custody, certainly change of parenting time, certainly it would at that point rise to the level of maybe he should be excluded from that. But I don't have anything other than a lot of, I started out telling you, a lot of this starts out saying, he's got an extensive criminal history, and I look at it and I see, holy smokes, he's got one driving offense in the last 15 years. Other than that, he does have history before then, but it certainly has not reoccurred. I did read through I think it was referee Magley. It wasn't a very complimentary thing towards Mr. Walker and his children, but I don't think it provides enough to require that he not have contact with the children or supervised at all times and things like that. I don't know what's going on, and I don't really know a lot of the underlying. I do see Mr. Walker, I don't care how you want to paint it, as being a knight in shining armor or whatever. Ma'am, you got to figure out having Mr. Walker contact Mr. Grable. He shouldn't even be doing it through text, quite frankly, unless it's an emergency. He shouldn't even be doing it. And that stuff that he sent was completely inappropriate. However, I don't even know why Mr. Grable is sending back even emojis or something to respond to it. I don't even know why you're even responding to this guy. You guys have got to figure this stuff out. I'm going to deny the motion at this point. You know what has to be done. So I'm not going to exclude him from being around the children. And but Ms. Grable better make sure it's always appropriate. It's her that's on the hook, not Mr. Walker. Good luck, everybody. You can draft the order, Ms. Johnson.
Thank you, Your Honor. Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Are we going to number 9? Well, I almost could believe it that we wouldn't go. Oh, number 20. That's my goodness. I haven't seen Allison Slate since I was a young man.
That's because I'm inherently reasonable.
Pardon me?
I'm just a reasonable gal. I just don't come to court on Fridays very often.
Could you put Allison on the screen for a minute?
Oh.
Good morning, everybody.
Morning.
Morning.
Matter of Mueller versus Mueller. Both parties are present. Ms. Bryant represents plaintiff mother. Ms. Slate represents the defendant father. This seems to be a pretty straightforward motion. You're asking for a specific parenting time because clearly every other weekend can't go from Thursday through Sunday. It just doesn't work because the kid's going to school. And so it has to be changed till Friday to Sunday. And what it sounds like to me is the only thing that you're really fighting over is the specific time for pickup and drop off. Is that a fair statement?
That's a fair statement, Your Honor.
All right. You guys haven't been able to figure this out? I mean, quite frankly, I understand that the kid doesn't get out of school until 3:38 is his out of school time. So obviously can't be there at 5. And I'm assuming that it's a couple hours to get there. I would think 6 o'clock would be pushing it to get there, but would probably be reasonable. In the winter, I only imagine that to get out, the bell goes off at 3:38, but I think kids probably have to get their winter clothes on and boots and change and stuff like that. Mueller, is he going to ride a bus?
No, he's not. It's near my home.
All right. All right. Well, I guess before I say much, Ms. Slate, is there anything you want to say? It's your motion.
Your Honor, I think it's just that, Mr. Mueller is going to lose a significant amount of parenting time. And that's just the fact of the matter. That's how this case ended up. Ms. Mueller moved to Michigan. And so that's what we have to deal with. So what we're asking the court for is some leniency in terms of the pickup and drop off time so that there's some meaningful parenting time on a weekend. Dropping off at 2 p.m. is a little early. I mean, we're on Central Time. We're going to be just waking up and transporting him back if the drop-off time's at 2 p.m. So we're asking for just a little bit more time.
Ms. Bryan. I read
Well,
your
already-
comments, and so, I mean, he's only a 6-year-old kid, isn't he?
I think he's 5, isn't he?
5, Your Honor.
Yeah. The one thing that I think that hasn't really been mentioned is the fact that this child has already been struggling when he was in his preschool developmental kindergarten program. And he had a lot of behavior problems. He was assigned a support team. He has a behavioral specialist assigned, a therapist assigned. He's in therapy now. So with respect to that time on Sunday, my client feels that it's very important that he just have a little bit more time to get started for this big week. And that's why the 2:00 time should continue, which is what they're doing right now. I would also note that we believe that Dad might be moving a little bit closer. I don't know if he's actually moved into his new home yet or not. We haven't received that formal notice. But if he moves a little closer, then they would be changing their midpoint time. And it looks, based on our best estimates, as though each party would be driving about an hour, 40 minutes. So that's going to help him if he should move into this home. And we don't know when that's going to take place. We don't know all those details just yet, but we would suggest that.
Winter around Michigan City and stuff like that, where it snows every day of the week and and stuff like that. I mean, I understand. It seems to me that he is giving up another whole day to get him another hour. So I'm not gonna make the time much different than it is now. But I think the parties can exchange on Friday at 6. That's maybe cutting it pretty close in the winter, but do your best. You got to get there at 6, and the exchange on Sunday would be at. I think you say it takes about 2 hours or less to get home, so we can do 3:30 on Sundays. You can stay, because it's also only every other week too. There's only, I mean, it's not every week that he's going to start out with the Sunday beforehand. So you can do 3:30 and 6. Should be reasonable for this young man to get back. 3:30 to be home by about 5:15 or something, and have some time to do whatever, to decompress and eat or whatever it is. I think that's fine. So Friday at 6 to Sunday at 3:30.
Okay, I'll prepare the order, Your Honor.
Good luck. Thank you very much. Take care.
This is Eastern Standard Time, right?
Yeah, I know of no other. I don't.
Okay, I appreciate it. Thank you, Your Honor.
Thank you.
Right.
Are we done? Yeah. Morning, Cheryl and Missy and all those out there, and Sharon and all the regular viewers. Oh, here we go. Mr. Han, good morning.
Good morning, Your Honor.
I'm wondering, are you on for any other case today?
I am not, Your Honor. Not that I'm aware of.
Okay, well, there is a case that I adjourned, Rodriguez versus Segura. It was to enter a paternity order.
Can I have the case number, please, Your Honor?
I'm getting Tracy to pull it right now.
Thank you. Okay.
And the father has been here twice before. He didn't notify you. He first time he came, he wanted a temporary order. And I said, I can't give you a temporary order until you're determined to be legal father. Okay. He came 2 weeks ago with that. But then I said, if you didn't notify the prosecutor, that I can't do that. They get to have notice. Okay.
So Michelle is assigned to this case.
I'm pretty sure I sent it directly to Yasmin.
Oh, my clerk thinks she sent notice of this to you.
Oh, gosh.
And maybe you can, we won't.
Tracy, when did you send that?
I sent it in her office. It would have been
2 weeks ago.
Yeah.
So 2 things about interoffice that I feel like I've been having issues with is that I'm personally not getting things. So I was actually in another case for a pre-hearing conference, and I got an email from Marie saying, oh, hey, we have a telephonic hearing today. And I was at home, like, what? So I had to hang up on somebody, like, tell them I'll call you back, and then jump into this hearing, and all my documents were here, but I was at home. So I've had tough luck with interoffice. I don't think I've seen it.
When you are done here, can you pull up because you have a DNA test shows that he's the father. Okay.
We do. And we have Michelle scheduled it for a pre-hearing conference for Thursday, August 15th. And we have something in the e-file. Let me double check. So we have a re-notice of hearing with remote participation scheduled, for today. So we did get that, but again, it went to Michelle, not to me.
You can send Michelle a message quick and check with her while we're doing this.
Okay, cause I want somebody to appear. This guy wants some time with his child. I can't give it to him until I get it entered. I was certain your office would not have a problem with it, but I gotta give you a notice and give you a chance to be heard, okay?
Yeah. I can, of course, Michelle's here.
Okay. When we're done with this one, can you get in touch with Michelle and stuff like that and tell her that this is on?
Yes, I will literally run to her office after we get
You
off
don't have
this.
to run.
Off this one. I have tennis shoes. I mean, I'm dressed for court, of course,
all
but
right,
I'm wearing tennis shoes. I'm ready for this.
Good. All right, then you can run to her office and see, and we won't call it, in the next 15 minutes or something like that.
Sounds good. So primarily parenting time, is that what I'm relaying to her?
Well, he wants parenting time, but I can't give it to him until I enter an order of paternity because he's not legal father. I can't give a non-legal
Gotcha.
father.
I'm following.
So, I'm not even sure if I will give him it. We'll see what plays out. I'm not making a decision on that or whether I'll send it to the friend of the court or whatnot. Okay. And I know your office doesn't get involved with that. They just get involved with the paternity part of it.
All right. I have made a note that I will take to her.
All right. So somebody I hope will log on that case and at sometime in the future. Okay.
Yes. Thank you, Your Honor.
Right. Thank you. We're here. McKinney versus Allen. Mr. Allen, can you hear me?
Yeah, I can hear you.
You have a camera you can turn on?
Yeah, I can turn it on.
And Miss McKinney, can you hear me? You're on mute. If you can. All right, if you turn on the camera, please. We have all the parties present here. We also have Ms. DeHaan from the Kent County Prosecutor's Office. This is Ms. DeHaan's request for a judgment of paternity in this case. I did see there as a result of DNA that is overwhelming, 99 point all those nines afterwards, showing that Mr. Allen is the father. Sir, do you have anything you want to say as far as that?
No.
You are the father, and we're going to enter an order that says so. Do you understand that?
Yep.
All right. Then we also are seeking to enter an order regarding UCSO, but it's a uniform child support order. Ms. DeHaan has gone through the calculations showing $228 a month. Ms. DeHaan, is there anything you wish to say?
Yes, Your Honor. Thank you. I did hold a pre-hearing conference with the parties on July 16th. Notably, Your Honor, the information before you, I believe, is accurate and appropriate. The child support recommendation per month is $228. That's $212 in base support and then $16 in ordinary medical. At the time of the pre-hearing conference, the plaintiff was agreeable to the amount, but the defendant was not agreeable to the amount. So I did allow them time to discuss. Oh, and we've also just lost Ms. McKinley, it seems. But I will continue.
See if he comes back, but you just stated that she was agreeable to this.
Was agreeable to the amount. Oh, she's back now. Perfect. So it was my understanding that she was agreeable to the amount, and it was my understanding that the defendant was not agreeable. So I did allow them time to discuss. I contacted them the next day in the afternoon. They were still not in agreement. As such, I set this matter for hearing. I do believe the documentation before you, Your Honor, the judgment of paternity, the child support order, as well as the calculations are appropriate. I am requesting entry of them today, but I will leave the parties to their arguments. Thank you.
All right. First off, Ms. McKinney, you agree that we enter the judgment of paternity as he is the father, and you're all right with the uniform child support order, is that correct?
Yes, sir.
Mr. Allen, what's your objection?
To what? Being a father?
Nope, to the child support.
Oh, we didn't even discuss after that day. To be honest with you, there was no discussion, so we didn't actually get to talk about it. She never called me, and I never called her. I assumed she was going to call right after that, but she didn't. Instead, she only calls about what she wants to call about, or whatever. But I feel like the amount they're asking for is a little high, especially letting them know my situation as far as already being on child support for one child, having full custody of another child, rent, phone bill.
You're being given credit for two children in the calculations.
2 children? What do you mean by that?
You say you got 2 other kids you're supporting that are biological kids. You're being given credit for that in the calculations. 700.
Yep, I wasn't aware of all that, but And it's not even just being credited that I pay child support for one of those kids, and one of those kids I take care of full time.
No matter that's what the calculations are in the.
Yeah, I still don't feel that's a fair amount.
Your Honor, if I may, I gave him credit for 4 additional children.
Oh, see, that's what I'm saying. That still is not making no sense to me because everybody's trying to.
So you only have 2 other children.
And it's like they
You
all
have 2 other,
call me even after the fact.
You have 2 other children you're paying for.
Nope, it'll be him and my other daughter. As
Okay.
far as I know.
So we're going to readjust it, and your child support is going to go up.
And why would it go up?
Because you won't get the credit for 4 children, you get credit for having 2 other children.
But I have 5. That doesn't make sense.
Well, you just told me you had 2 other children.
No, I said 2. I said I have 2 that I would be paying child support for, sir.
This one and one
how many
other?
kids I had in total? If we're talking in total, it's 5. But if we're talking about me having to pay child support for them, it's 2. It'll be 2, including Zakai.
So you have 5 kids, one of which is this child that you are now the father of, correct?
Correct.
All right, so you were given the correct amount of having 4 other biological children, even though I'm not sure that you're paying child support on 1 or 2 of them. Do the others live with you?
My oldest daughter lives with me, but the one that I on child support does not.
All right, one that you're paying child support does not. One oldest child lives with you, and you have 2 other biological children that do not live with you?
Yep, 2 sons.
And you're not paying support on them?
Not right now. I think I don't know. They be giving her a hard time with emotions. I don't know what they're doing.
All right.
I'm pretty sure it'll be coming eventually.
Mr. Hahn, he's not paying on the other 2, so he gets, as far as I'm concerned, he gets credit for 2.
Our office policy has typically been that we give the individuals credit for the amount of children that they have. But if the court would prefer me to give him the adjustment.
No, your office policy is fine. He's getting credit for all of those kids. He's also, I've gone through the factors. He's imputed at $15 an hour times 35 hours. He has earned that in the past. He's at least the amount of $15 per hour. He's also earned more than that at times. He has the ability, as a high school education. There's nothing that seems to prevent him from working at that minimal amount. Her calculations were also imputed at $18 an hour times 36 hours. Mother hasn't objected to anything. Father's objection are just that he doesn't really want to pay that much because he says he really doesn't think he can. That's not a valid objection or a deviation. Therefore, I'll enter the order as presented.
Thank you, Your Honor. I'll have that sent to you via DocuSign.
Thank you, everyone. Good luck. We're adjourned.
Oh, funny as hell. That doesn't tell me shit. So I got a question. It didn't sound like nobody had anything to say to me. So how is that fair?
I already listened to your stuff, and it doesn't. There's no objection. There's no valid objection to it, so I'm entering the order. Thank you. DM Martinez Sosa versus Monterez. Both parties are present via Zoom. Mr. Martinez Sosa is represented by Ms. Jernigan. I read your, this is a motion by the mother regarding parenting time violations. She says that, he didn't bring the kid to her on certain days and all this kind of stuff. And she's missed time. She wants some makeup time. The response basically says that that's untrue, that he does his best to get her parenting time. Ms. Monterez, what do you want to say?
Well, I thought this was like a meeting to renotice the hearing again.
This is your motion you filed and set it for today.
Okay, I thought they were gonna renotice it because I have the kids for this week for my week in the summer, one of the 2 weeks on consecutive weeks in the summertime, my parenting time. And it started Monday, but he brought them all the way to 11 at night because Hilario Jr. was at work, and I asked him why did he not.
This is your motion, all right, because you say you're not getting your parenting time. Number one, I read in your judgment, he doesn't have to bring them to you. You got to go pick them up. That's in the judgment, Ms. Jernigan. unless there's some change that I didn't see.
No,
So
I'm sorry, Hilario and I came into agreement that he was gonna drop them off at my apartment
Well,
and I was
that's
gonna
not an
take them
enforceable
back.
agreement. It's not enforceable because I'm not gonna enforce it unless you have it in writing that you're gonna do this kind of stuff. The judgment calls for it right in a paragraph, and I can read it to you, that the person starting the parenting time is the one responsible. Parents shall equally share the responsibility for transportation unless otherwise agreed in advance. The parents beginning their time and with the minor child shall be responsible for transportation. If you have that in writing somewhere, I'll enforce something different, but until then, that's the only thing I'm enforcing. Number two,
So-
if you think he's violated some parenting time, file something with a friend of the court. That's the way you enforce it. You file a complaint with a friend of the court, they investigate it. If it's found to be valid, and you can't work anything out, it comes to me on an order to show cause, and I make my decision. That's the way it goes. I'm not gonna sit here and decide whether or not he was 10 minutes late, or you didn't have Mother's Day, or that's up to you to file with a friend of the court.
I understand, Your Honor. My question is, where do I go for Hilario and Alina if I do not have an address to go pick them up?
I assume he lives at the dad's. How'd you serve this on him?
On his old address? Well, the court did not give me an updated address on him, or he have not let me know where he lives, so I can go pick them up.
Ms. Jernigan, anything you want to say about this matter?
If I could just inquire to my client, ¿usted vive aquí? A decir su dirección.
I'm not.
Address. This is not.
¿Ella sabe dónde vives?
Sí, ya sabe porque I receive Giselle.
Okay, so my client indicates that Melitza knows where he lives, but I do have Melitza's email, so I'll make sure I get my client's residence address and I will send it to her via email right after this hearing, but my client states she knows where he lives.
All right. Anything else? I mean, basically, these are requests for violation of parenting time. Those are to be filed through the Kent County Friend of the Court. They do their investigation. If it ends up in front of me, it does, but I'm not gonna deal with them on a Friday morning.
Okay.
You understand? I'm sure you do, Mr. Jernigan. You know what I'm talking about. Ma'am, do you understand what you gotta do?
Yes, Your Honor. I did not know that before, but now I do.
All right. All right. Is there anything else we need to address?
No, just maybe communication. If Melitza, I think Melitza has a phone number. I'll email her. I want to make sure I have her correct phone number because my client states that the numbers changed quite a bit.
All right.
So we just need
She's
to.
gonna email you with his address, even though you know where he lives now. She's gonna make sure it gets to you this afternoon in your email. And
Yeah, I want to say something also. I'm sorry for interrupting you, Your Honor. About the telephone number I gave him, he's always had Giselle Rodriguez's number. I gave him my number once. He did not know how to respect boundaries, so that's why I changed my number, because I have to work the next morning and he wants to argue about the past. And right now,
it doesn't matter. We're gonna find out the number. If something else comes up, I'll deal with it later. Mr. Jernigan's.
I'll talk to him about that, but he has communicated with Giselle, so.
All right.
Yes, yes.
She will be in contact with you, ma'am. Other than that, basically your motion is denied, not because I'm saying there are no violations. I don't know. You will any claim to violations will go to the Kent County Friend of the Court before coming to the court.
Okay, thank you, Your Honor.
Will you draft that, Ms. Jernigan?
I'll draft the order, Your Honor. And then for the record, Melitza did drop off a renotice to my office yesterday, but I take it that was
why are we re-noticing this, ma'am? You got your time, you know what you got to do. So there's no reason to have a hearing 2 weeks from now. Right?
Well, I'm kind of confused because you're saying I have to go to the friend of the court to put a modification in for my parenting time that I have not had because I did not know I had to go through the front of the court instead of the court that I went to file paperwork.
I'm telling you, you got to go through them. So if you come back 2 weeks, I'm going to tell you, you got to go through the friend of the court.
Yes, I understand now.
Thank you.
Thank you, Your Honor.
Right, we're adjourned. Thank you, Mr. Jernigan.
Have a good weekend. Bye.
You too.
Thank you.
Good morning, Miss Smith Lowe. How are you?
I'm well. I'm a little, my heart is, I got a little jolt to my heart this morning.
At least
that
it's beating. That's all I really, I want to, as long as you tell me it's beating, that's good.
it's beating, but it
All
was
right.
jolted this morning to know that I had a hearing that I wasn't aware of.
Well, that's, I remember practicing and we probably, Tracy's trying to cover for you and take some blame. So
Is she?
she said she should have emailed you and stuff like that and told you about it, but she just sent us over to your office and.
We didn't get notice.
Well, yeah, Yasmin said she did. Yeah, she looked on the computer and she said we did get some notice. It doesn't matter. Okay.
Okay, I'm sorry.
I mean, we're here in the matter of Rodriguez versus Segura. I'm waiting for her to connect. Mr. Segura, you can hear me all right?
Yes, Your Honor.
Thank you. We've been here twice before, Miss Smith, and adjourned it twice. Just so you know, the first time he was asking for parenting time with the child, and I said, "You're not even legal father. I can't give you anything." Okay. Then he came back 2 weeks ago and said, "I want parenting time to enter a paternity order," which apparently you do have a, you know, that he's 99.9% parent. And I said, "I'm sure the prosecutor probably doesn't object to it, but this is their case and he can't come in without giving notice to the prosecutor." So then we sent the notice over and then it got lost, which was perfect. And then, but now we're all together. And as soon as Miss Rodriguez enters into this, we can deal with it. I guess up front, I can kind of ask you, even though I don't know why she's not connecting. You do have a paternity test and I assume you don't have a problem really. He is the legal father.
He is not the legal father yet, Your Honor, but the genetic test results indicate that he is by scientific probability, he is the biological father of this child.
But I misspoke myself. I'm about to make him father, okay? Because you certainly don't have an objection to entering a paternity order.
I do not.
And I can't imagine why Miss Rodriguez would have an objection, but she just won't connect.
I'd like to hear from her. There's no other reason that I know of that he, to
I'd like to
object
hear
to.
from her too, and I wish she'd connect.
Hello?
Miss Rodriguez?
She stepped aside to the restroom really quickly.
All right. Please get her there as quick as you can.
Okay, sounds good.
All right, Miss Smith Lowe, if you would lead us in a song while we wait, I would appreciate it. Pick your own song, or if you want me to pick one, I can, but I would rather you pick your favorite.
I don't know if you want to hear my early morning voice.
You mean your one that you're shocked that you're even here to begin with?
Yes, that one. That one. Somehow.
I've heard Mr. Segura sing a couple times while we were waiting for things, and it's not pretty, so I'm not gonna make it.
I try not to. You know, it's hard, when you have to leave the voice out,
Yeah. All right, here we go. Miss Rodriguez, can you hear me all right?
Yeah.
All right. I've called the case, and we have you present, Mr. Segura, and we have the Kent County Prosecutor, Ms. Smith, all present with us now. As I stated before, Mr. Segura has come before me twice. First asked for parenting time, and I said I can't give parenting time to somebody who is not even adjudicated as the father. He came back next time with the paternity testing that shows he is the father, but he hadn't notified the prosecutor's office, so we re-noticed it again. Prosecutor's here. I intend to enter the order of paternity unless you have some kind of objection to it. He is the father based on the DNA testing. Do you agree with that?
Yeah.
All right. So with everybody's agreement, I guess we will enter the judgment of paternity. I don't know if I have one in the file, but if not, I'm certain that I will get one from the prosecutor for DocuSign soon. Okay.
I can send that over, Your Honor, and we will still schedule a pre-hearing. Actually, I have a pre-hearing conference scheduled for the 15th, actually August 15th. So
right.
I will meet with the parties regarding child support at that time.
All right, and that's coming up real soon, both parties. Do you know about that meeting?
Yes, Your Honor.
Ms. Rodriguez, you also understand?
Yeah.
All right. The other thing that Ms. Smith Lowe won't necessarily be involved with though is Mr. Segura would like to start some kind of parenting time. Of course, he's asked for 50-50. I don't know what's appropriate. We'll get into it. But when was the last time you saw the child, sir?
4/28 of 2024.
All right.
That should be on a Sunday.
All right, ma'am. What can we do about getting him at least sometime between now and then? We can send it to the friend of the court for parenting time, custody type of review.
I'm not too sure because I did put out an order, like a PPO order out against him, so I can't really I guess.
Is the current PPO against you, sir?
Yes, Your Honor.
Okay. I mean, that doesn't prohibit him from having some time with his child.
Yeah, well, I guess I'm just saying because on there it says that he can't remove, I guess, the minor child here. It says that's checked off right there. I guess except
he
as
can't
allowed.
come and steal the minor child and stuff like that, but he is the father.
Yeah.
Are you saying you don't want him to have any parenting time?
I guess as of right now, I just don't want to. Before I did. I've tried to give him time on the weekends is what we had, and days where he either didn't have school, so he would go over there because I would be working. And I don't know, I guess personal issues that he has against me is what was making it difficult.
He's going to have to get over those personal issues because it's going to affect his parenting time at some point, but I don't know why.
Yeah.
I mean, where could he see the child? Sir, do you live alone? Do you live with parents or what?
I live with my current partner and his sister.
His sister?
Yes.
And you're
not the father of my child's sister. It's my partner's sister.
all right. And sir, where do you live?
I have my own apartment complex, sharing it with my other partner. That's not Yasmin.
Do you have parents or anything involved? I guess what I'm trying to do is get you at least like several hours on a Sunday or Saturday, but I'm trying to keep the two of you apart at all times. We'll send it to the friend of the court for their evaluation, but I want you to start seeing your child. All right?
That's right, yeah.
But I don't know what I mean, do you have parents? I'm kind of going to make it supervised right this minute. All right. Just can you exercise Sunday or Saturday? I don't care which, from 10 o'clock till 6 o'clock each Saturday or Sunday to be exercised at your parents' house or something? Ma'am, does that?
I can do, because the only person that I feel comfortable is at my aunt's house. I don't have my parents aren't in my life right now, so
I'm not at your parents. I'm telling
are you talking about
his parents?
His parents? Okay. I don't feel comfortable because his family, they have just basically harassed me, his
So
sister.
you think his family, so you think if the child goes over there, they're gonna barbecue the child or something? I mean, what do you?
I'm not sure, but
How old is this child?
He just recently turned 5.
All right. So he probably knows the other family.
Yes, of course. Yeah.
Is he, have they beat him? Have they done?
No, but he has come home multiple times with cuts and bruises on him from whatever. I don't know what.
Would you rather than that Mr. Segura just has it parenting time from 10 till 6 o'clock without the supervision of his family?
Yeah, that's what I'm saying. Yeah. I don't,
All right.
I don't know.
Which day works better, Saturday or Sunday?
Sunday, I guess. Yeah, Sunday.
Every Sunday, 10 o'clock till 6 o'clock. This is just, in the meantime, I'm going to refer it to the friend of the court for custody parenting time type issues. I'll waive the fees. Sir, I'm going to tell you right now, if you, how do you want to do the exchange? Because the two of you really shouldn't be together. Ma'am, can you pick up? How do you want to do this?
I can have them pick him up at a family member of mine that I feel more comfortable with.
What about exchanging at a police station or something? I mean, there's cameras there and stuff like that.
Yeah. I'm just thinking more of how our son is gonna react to,
Well, I got a lot of emotions. I'm trying to figure this out.
Okay.
Where do we go?
Yeah, that's fine.
No, do you want to, at a family members there?
Yeah, I have my aunt who I feel more comfortable.
Does he know where your aunt lives?
Yes.
Yes, Your Honor.
All right. We'll exchange at 10 o'clock there, ma'am. Then you don't have to see him or be around him as long as there's a PPO. I don't want you around him. Pick up and drop off will be at the aunt's house. And sir, fair warning, you mess up at all with the abuse or anything about that, and I'm going to sink your ship. You understand that?
Yes, Your Honor. May I have my word in yet?
For what?
About the PPO, some of it was false. My height was wrong, weight was wrong.
So what?
Age was wrong for the PPO.
It's a PPO against you. It's been served on you, right?
Yes, it has served, but with false information.
And it is in effect. You're not going to argue against the PPO here.
Okay, well, what my age is wrong, my weight is wrong, my height is wrong. I don't know if that matters.
No, it doesn't.
Okay.
It's you.
Okay. I just wanted to see how they accepted it. Because I only visited to her once, and that was to serve her. That was to serve because she didn't answer. I just left that on her windshield.
That's a PPO issue. If you want to argue
way
enough,
before. That was,
that's nothing in front of me right now. I'm trying to get you some time with your child, and you're starting to make it difficult.
Okay, Your Honor. I'm sorry.
Right? Every Saturday, what do we say, Sunday?
Yes.
Every Sunday, 10 till 6. And I'm telling you again, because people can have cell phones, and if you go to pick up your child, and you make sure your aunt is respect.
Yes.
All right?
Yes, of course.
You make sure that I don't want him having problems. I want him to be able to go pick up the child, bring him back. Okay. Anything that goes on between them, you guys can you can take videos of it, bring it to me, bring it to the friend of the court. And I'm telling you, it won't go good for whoever is the one who is the inappropriate. Am I really clear with that?
Yes, Your Honor.
Mr. Segura?
Yes, Your Honor.
All right. You'll still have a pre-hearing conference with the prosecutor on the 15th. Make sure you attend that also.
Your Honor, may I ask you a question? You're referring it to the friend of the court for custody. We can certainly prepare the judgment of paternity and send it to the court.
I'm going to refer it also, I think probably might as well do it for child support.
Okay, that's what I was asking. So then we can let both parties know that the 15th, they don't have to meet with me, but they'll meet with the friend of the court for custody, parenting time, and child support.
Yes.
Okay.
They will, they're going to send you something. If you don't respond to it, they're going to work with just the other party. Okay.
Okay. Is that getting sent through like mail or?
I think they'll mail it to you and probably email, but I don't know what the friend of the court does. Whatever your last known address is to them, you better make sure that the friend of the court has an appropriate address for you. I don't know what it is, and I'm not going to read it because we're on YouTube, but for you, ma'am, the only address we have starts with 847. Is that correct?
No.
Well, then you better make sure that we get your address correct so that we can send stuff to you, Mr. Segura, 2213.
Yes, Your Honor.
All right. Ma'am, make sure that we get your address.
Your Honor, I can send it to the court. I think we have 1100.
Yeah, 1100. Yeah.
Yes.
All right.
Okay.
All right. If you could send it to us, I'd appreciate it. Okay.
I will. And along with the judgment of paternity.
With the judgment of paternity, make sure the friend of the court has your 1100 address too, ma'am.
Okay.
All right. Well, you're not going to put the parenting time. We'll do a separate judgment for the parenting time. All right.
Okay.
Miss Smith Lowe, you don't want to put in there the parenting time.
Oh, I can put in what you've ordered, the temporary parenting time that you've ordered.
Okay, that'd be great.
So far.
All
Okay.
right, thank you.
All right.
You'll all
Thank
get a
you.
copy of that. Good luck. We'll see you. If you can't figure something out with a friend of the court, we'll see you in the near future. Good luck. Thank you.
Thank you.
And that will take an effect of this Sunday?
Next Sunday, it starts.
Next Sunday?
Yes.
Oh, you keep waiting.
It's really close to this Sunday, and I'm just going to let her get ready, and she's got to call her aunt and all that kind of stuff. Okay, I got to make sure that the aunt's around and everything. It can start next Sunday. Good luck. Thank you.
The 18th.
Yes.
The 18th. So long.
All right. Good luck, everybody. Thank you. We're adjourned.
Thank you, Your Honor.
Thank you.
Thank you.
DM, both parties are present via Zoom. This is a motion made by the father, Mr. Aldridge, regarding custody. There was a consent judgment that was entered back in 2017, where it appears the mom got the kids during the week and dad had them from Friday to Sunday. He now claims that the kids have been in many different schools. There's some attendance issues there. She uses the kids as a babysitter. No set bedtime for the kids. Says the boyfriend has a drug problem and is mentally abusive. But then it also says mom has moved back in with her parents, but he's got problems with the grandparents also. Makes the kids feel guilty that they want to spend more time with the dad. That's in essence what he says. She's been in Pine Rest. Sir, anything else? What do you want to say? You got to meet a standard called Vidvarka, means proper cause or change of circumstance since the last custody order was entered. So
yeah,
tell me how you meet that.
I just would like to have the opportunity to have the kids in a more stable, healthier home with more consistency of their mental health, because they've been moving around so much, so many different schools. You know, my oldest is 13 and she acts like the mother of their half brother, and they don't have any sports they get into. I would like to, no organized sporting events for school. They get promised that, but then nothing gets followed through with.
What is sporting events? I mean, you got a 13, 12 and 9-year-old.
Correct.
And they're saying they want to be involved in extracurricular activities, but what is it that they want to be involved in?
Olivia wants to do softball and horses. Annabelle will do cheerleading and volleyball. And then Charlie wants to do football, wrestling, soccer, everything a 9-year-old boy wants to do. So we just got Annabelle into cheer camp this week. And then we got signups for flag football for Charlie, and Olivia is next. We have school already lined up and paperwork already processed for them to go to school with. It would be my fiance's other 2 children. All 5 would go to school together.
Where did they go last year?
They went to Eastern, Forest Hills, Eastern, and Knapp. Oh no, sorry, they went to Kent City last year.
All right, and where are they scheduled to go this year, ma'am?
It would be Hopkins, with the other 2 maybe step siblings.
Let me hear from Ms. Aldridge for a minute. What's your response?
Olivia just returned from a trip to Florida with 4 of her friends. Her attendance issues began at the beginning of the year because she did not want to move. She had an in-house suspension at the beginning. In terms of using her as my babysitter, I can verify that I paid for a babysitter, and then he was also in a formal daycare for the duration of the year. I only worked 2 days a week, or I did at the time. Saying that I have moved them to schools. We initially moved here in 2018 into the Forest Hill School District. We moved out of the district for the first time last year, and Kent City was not a good fit for us. And so we came back to Forest Hills. Charlie has been involved in lacrosse. He has participated in a Ninja Warrior class. Annabelle has done volleyball. She has done, just this year, she's done volleyball that Adam has been to her games. Charlie, he's this year, he just he didn't get into much. He was really sad about not being able to redo lacrosse again because Kent City doesn't have that team. And he participated in it last season with his cousin, who also is at Forest Hills Eastern.
Let me ask you this, because I'm not sure. You say the kids have attended Forest Hills for almost the whole time, except for 1 year last year, Kent City, and now they're back in the same school that they were in before?
Yes, sir.
Sir, what? I mean,
they've been to Cooper.
Olivia went to Coopersville for kindergarten. For kindergarten and first grade, they were at Harrison Park. But Libby was
in the
in,
first grade there, she's gotta be she's 13.
yeah.
I mean, so what, she went to Cooper's. I'm saying she's primarily over the last 4 or 5 years, the kids have attended Forest Hills. They went 1 year up to Kent City and now they're back in the original school.
Yes. And they're enrolled. Everything has been taken care of.
Sir?
Yes.
What?
Yeah, before that they were in Coopersville, and then school off of Leonard and Harrison, and then
it sounds to me like that would have been 5, 6 years ago.
Correct. They were what grade were they in? Third and fourth? No, not third and fourth. Second.
No, they were in first. They were in
second. Second and third was, I think, Harrison schools.
I'm saying no. It's been, how many years were they in Forest Hills, sir?
I believe 3 years.
3 years.
2 on, 1 off, and then this year, if they go back, it would be this year.
Well, they're going back right now. We'll see if you want to fight and train schools. That'll be a Lombardo hearing, but it seems like they're returning to the school that they are used to, and everything. What else do you have to say? I mean, I don't know what there is to find a preponderance of proper cause or change of circumstance to have a custody hearing.
Well, Olivia, last year almost failed 7th grade because of how much school she missed. She missed it goes by period. First hour, she missed 70 hours. Second period.
I read your stuff, all that she missed. That's one child. And
and then my second child missed 33 hours and then 26 hours. So there's a consistency of absences and for school there. And a lot of the time, from what I've
said that it wasn't a good fit. She said she's moving them back to the original school.
They're a good fit because they didn't really go to the school. They missed so much school that because they had to stay home and be the mother's babysitter for their half child, which is I witnessed when I went over there one time to return a computer. All 4 kids were there by themselves on a Monday, not at school, watching their half brother, and they should have at least all 3 of them should have been at school, and the half brother should have been at daycare.
When was that you went there?
It was. I have pictures of it.
Tell me about when. I mean, was it winter or what?
It was winter. Yes, it was winter time.
Why didn't you file this back then?
Well, I didn't feel that I don't know. I should have. You're right. I should have filed it then.
Why didn't you? Did you talk to the schools about this and try to correct some things and stuff?
I called the school and asked how much school they missed. I didn't realize how much after that happened in winter. I didn't realize how much school they missed. And then I called later and figured out how much school they did miss.
When did you call then?
It would be in June.
After they were out of that school?
Correct.
And after you know they're going back to the same schools, right?
Yes, that's the original plan, yes. Yeah, she has she put them on HDHD meds that I had no idea about. Apparently my oldest only takes it when she's tired, I guess.
Don't you have joint legal?
Correct. I was not told about any of the medical changes. I was not aware of it until my kids told me that they were on HDHD meds. 2 out of the 3. It would be Olivia and Charlie.
ADHD? Are you talking about ADHD meds?
Correct.
Okay.
There's also, I just see too much, the kids they don't rely on her. She was 2 hours late to pick up Annabelle from volleyball. She was sleeping.
No.
She was late to take Olivia to her Florida trip. Because I got a call from my daughter at 3:30 in the morning and said, Mom's 2 hours late. So I jumped in the car to go grab her. And then all of a sudden Mom shows up. And this is 3:34 in the morning. Also, I found a prescribed inhaler in my daughter's backpack or whatever that her mother gave her to use for asthma. She wasn't prescribed for asthma. She wasn't prescribed an inhaler. It's an inhaler for albuterol.
Okay, have you talked to the doctors about any of this now?
She did not. No, I just found out. No, I didn't know.
Why haven't you? Do you know who the kids' doctors are?
Yes, Dr. Igerson's office.
And you have Mom's shaking her head no, that it's not that doctor. Do you know who the kid's doctor is?
Yeah, it's Gail and it's Family First Pediatrics, or I can't remember the name of it. I have it on my phone.
Where is it?
It's right there in Cascade-ish, Ada.
It doesn't.
Right off of 196 and the Beltline there.
All right, ma'am. One thing I'm not gonna put up with from here on, all right, is he's to know all doctor's appointments.
He's been aware of it.
I'm telling you right now, you're not gonna put kids on medication without getting it to him. I know you're gonna say he knew about it, and he says I don't, and I can't figure it out here today on a Friday morning, whether he did or didn't, okay? But
Yep.
you understand what I'm saying. Joint legal, I'm going to enforce that, and I'm not doing anything right now. I mean, I don't know, all right? I don't know if you told him or not.
Right. I understand. And it's A+ Family Medicine, and it's off of Michigan Street, and they've been going there since they were born. Olivia, she had saw one physician 13 years ago for her first home visit when she got home from the hospital, and that was at Cascade Pediatrics. But from there on out, they've had every single vaccination get administered since that. From there on, from the same medical assistant. They've seen the same, Adam has seen the same physician there too. He was also a patient. I've had, Charlie was also, I've got notes. I printed off Charlie's, all of his doctor's visits with the notes from Gail, including the school psychologist who did a behavioral analysis on Charlie, in addition to Mrs. Ewing, who was also Livy's teacher and then was Charlie's teacher, on her concern of Charlie's impulsivity and how it was creating such a boundary to make him even have friends. It wasn't a matter of as for Olivia just has the prescription. It's not like she is consistent with it. She hasn't taken it, but Adam was aware, and it was also discussed between the physician, especially with Charlie, because Adam was not going to administer it. And at that point, it would have been neglect on my part not to, because it was within the best interest of my child.
Listen, this is how it works. You have joint legal. He knows about it, you know about it. If you can't agree, I gotta make the decision.
Okay.
And I don't want to. I'll tell you this right now. I do not want to make those decisions because you guys gotta do it and everything, but you understand, the rules are the rules, all right?
I know. I understand.
If you guys can't get along, then I gotta enforce these rules, all right? Yeah, are you currently in a stable residence? Is that with your parents?
Yes. Yep. We are good. And my significant other he doesn't even have a criminal record. I don't know where he could allege that he even is a drug abuser, or that my dad is an alcoholic. These are just
These are just allegations, and I get this all the time. And
okay,
I mean, does your dad have a recent drunk driving charge or anything?
No, he was a vice president of a winery for over 30 years and has never had even a hiccup. So,
all right, where's your proof, sir, of any of this kind of stuff?
Well, my proof was the other week, where he came up to my car when I dropped my daughter off, and I could smell the beer and cigarettes on his breath, and he was yelling at me about when his dog bit me, and I called the cops on his dog. And then he was yelling at me and threatening that he would kill me if I ever called the cops on his dog again. And then he punched me in the jaw. And he has a drinking problem. He always has.
Has he been charged with anything?
No.
I have the police report.
I don't care. Has he been charged?
No, I don't know that.
I mean, I don't know. And what do you have about the boyfriend? Has he been charged? Does he have criminal charges?
On steroids, from what I understand. Cops were called on him for that, for him acting erratical. So the cops are called on that. That's when they're living in Kent City. There's holes in the walls from him hitting the walls, losing his temper. And that's what.
When did you find out about that? Why didn't you find it?
The kids told me about that. Yes.
This is like he said, she said.
Yeah.
Okay.
Right. Most of it is correct.
And I got to have something of probable cause for proper cause or change of circumstance to have an evidentiary hearing. Nothing I've heard so far raises to that level, because I mean, I don't have anything.
I mean, I don't think the kids will be in a great, healthy environment going back to their grandparents, because the grandfather's a drinker. He came up and punched me in the car while my daughter was there.
That's between you and the grandfather and the dog and all this kind of stuff. That's not enough to change custody, because you don't get along with the grandfather, and because he's ticked off at you because, you know, you said his dog bit you, and then you called the police, and he's mad because you're trying to get his dog, you know, euthanized probably. This is
all three kids said that they would like to live with me and go to school.
Yeah, well, all three kids, that cannot be a reason. Okay, it is not allowed in the first place. If we had a hearing there, I would interview them for their preference, but that's only one of like 12 factors.
Right,
And it can't be used as saying, you know, the kids want to come live with me. That's not cause or change circumstance.
With a lot of the school that they missed too last year.
Well, that's the closest thing that I even hear to anything, but I don't, ma'am, you're
Their
aware.
absences at Forest Hills were less than 5 the previous years. I think at most, when Charlie had COVID, he missed 8 days, but it hasn't even exceeded 10 days in the last 4 or the years prior.
All right. Well, look, you're on notice right now that if these kids do start missing any substantial school, that will be enough to.
No, I understand that. It was, a lot of it was adjustment. I'm a nurse, so I had to leave in the mornings, and it was an expectation that was set forth. Livy was old enough I would wake them up, get them ready, get Mab ready for daycare. And they just needed to get on the bus. Everything was set forth, and I would get text messages saying, "Mom, I'm not going to go. I don't feel good." And I worked at Trinity Health at the time. And before that, I was working with hospice, and I didn't have the flexibility just to leave what I was doing at my job.
I don't believe, at least at this point, that Vidvarka has been met. I'm just warning you.
Right I know. Okay. I was just explaining myself.
I'm just okay. I got others to get to here. So I'm just warning you here and now that you're aware of what his concerns are, and they will be my concerns if the kids start missing more school. Although I don't have anything to show truancy. I don't, if they miss so much time, usually Kent County will get involved and talk about truancy, send out truancy letters and stuff like that. I don't have anything on that. I don't, as far as setting time for kids to go to bed, that's not an issue. I don't know that, I mean, you say he's got the boyfriend has a drug problem. Is he living there also?
Nope. We decided just to go back to what made us all good and where we were at and build from that.
All right. It doesn't appear that he even lives with the kids now.
No.
As far as the grandfather having a drinking problem, I don't have any proof other than he punched you because he was mad because you tried to get his dog taken away, probably. And this idea that the kids are being made to feel guilty because they want to spend more time with dad, that's and that the kids want to live with him, that does not form the basis for a Vidvarka finding for having a custody hearing. If you can provide me other more specific or more, if there's some evidence of some things that you allege here, I'll take another look at it, but at least at this point, I have to deny request for custody because I do not think you meet the Vidvarka standard for proper cause or change of circumstance. And I'm not going to put up with any other stuff about joint legal. It's not, I mean, you can't even tell me where the kid's doctor's is. Sir, that tells me something also. So good luck, everybody. I'm going to deny your motion. Thank you.
Thank you.
Both parties are present via Zoom. Mr. Keeler represents the plaintiff. Ms. Schenk, this is a motion to adjourn an evidentiary hearing, which we have set for custody on September 9, 2024. The reason being is that Mr. Schenk is incarcerated and is facing some serious charges. Are you set for trial in December, sir?
Yes, sir.
All right. Do you have any thoughts on adjourning it? That seems to be reasonable that we would set it for some time after your December. I mean, set it somewhere in January or something like that after your trial.
Yes, sir. No, sir. I don't have any.
All right. All right. Then, Mr. Keeler, I'm going to grant your motion. We'll adjourn it. We will set it up for some time first part of the year, to make sure that, hopefully your trial on the criminal, matter will be over with. Okay?
All right.
All right. Good luck, everybody. We'll send you notices. Anything that, I assume there's no real time that you have in January or February, Mr. Keeler, that we have to avoid.
No, Your Honor. Nope. We should be wide open to the court's
All right.
discretion.
We'll send you
Yep.
out some notice on that. Okay? Good luck, everybody. Thank you very much.
Thank you very much. Bye-bye.
English v. Walker, we have Mr. Walker. I assume you can hear me. I can't see you or hear you because you're on mute. Can you tell me whether you're there or not?
Yes, I'm here.
All right. Mr. Walker is present with his attorney, Ms. Wolfram. The plaintiff filed this motion for a confidential address as well as for custody. However, my clerk has told me that, was this set for our 8:30?
Yeah, and it looks like a text would have went out to her, assuming that we have the right number in the system.
Miss English has never logged on. And we are 10 after 10. I assume that everybody's been waiting since about 8:30 for this thing. And so, Ms. Wolfram, is there anything you want to say?
I guess I would ask the court, well, I'll just preserve for the record that I'll file a motion for attorney's fees here. I'd ask for her motion, whatever it is, to be denied since I haven't even reviewed it, but she's not here, so.
Yeah, she filed a motion for custody.
I mean, my client has recently gotten back in touch with me regarding this motion, and he has also already detailed to me a number of violations that she's made about not returning the child on time and violations for joint legal custody. So I'll really talk to her, or talk to him rather, about what she's been doing. But at this point, this is kind of in line with her behavior of filing motion and not showing.
But the only thing she filed that had any substance was she sent me a letter from the 11-year-old child, which I will not read.
Okay.
I will not read kids' letters to me on custody motions and whatnot. It's inappropriate. And just so for the record, I did not read it and will not read it. Because I have no idea how the kid wrote it. I have no idea if mom sat there and said, hey, write this, or whatever. I just know it's from the 11-year-old. Once I found out it was, and I suspected it was, I did not read it. So I guess I will be denying her motion. She did ask for a confidential address, which I probably would have granted. I assume that wouldn't be any problem, but I'm not even going to grant anything since,
It's probably not a problem, except that I'm worried that perhaps her request is due to the fact that she's previously had unstable housing, which is the cause of our previous motion, been in shelters and things, which again, understand that that doesn't preclude parenting time, but it does make my client worried about her stability and safety. So that would be my only concern with it being a confidential address, is that it's to hide that instability.
I'm not going to grant it now because she didn't even show up.
Sure.
So, and we don't, I mean, I can look, she's not here in the courtroom. The door is unlocked for people to come in. If she had shown here, she's not logged on. She's done nothing. So I'm going to deny her motion for the reasons that she hasn't shown up to show anything. I don't even know what her proof was regarding Vidvarka to even begin with, but I would have heard her motion and seen what she had to say, but everything will be denied. You can do what you want as far as attorney's fees.
Okay. Will the court be issuing the order denying, or do I need to submit one?
We'll just do a form one really quick. All right.
Okay.
So you don't have to do this one. Good luck. Thank you, everyone.
Have a good rest of your day.
You too. Number 9. We're getting right through these.
We are?
There's not a lot left.
No.
Holy smokes, all those YouTubers are gonna be able to go home early. This is number 19. Yeah, well. All right, well, I see here it's 19. Yeah. Well, you got your numbers pretty good. You've been ciphering pretty good, but.
Say numbers, if
Yeah.
right.
Good
morning, Judge.
Good morning, Mr. Tom. We have Miss, Deborah, but it's Miss Tom. We have both parties are present via Zoom. This is a motion by the defendant father regarding child support. Says he didn't know about the review, which, I mean, as far as her requesting it from the friend of the court, you wouldn't necessarily know, and it doesn't matter because then they send stuff out to you, sir, and you got excuses as to why you didn't respond, which I don't get it at all. I mean, you were moving, but I assume you got other mail, and You would have put in a change of address or something, so I don't know why you didn't get it, and I hear this all the time. More likely you didn't pay any attention to it. Friend of the court made calculations. What about the calculations are you complaining about, sir?
Well, first of all, when we got rid of the child support before, we both agreed, and you or the other judge, I'm not sure which, had told Vanessa that once we get rid of this child support, we're not going to go back on this. And
Child support's child support. The court can't really. I mean, if you had won the lottery or something, if there is. I mean, I don't see anything in a judgment that says this is forever, and that there is something that prohibits her from asking for child support.
Okay. The other thing is in the child support or in their I didn't get a chance to. There's so much has changed. I have a mortgage or a rent now. I have 3 other
None of
children.
that matters.
Okay, but I mean, I wasn't able to even put that in because I never got the paperwork.
But
and I understand the address didn't get changed, but I didn't even think to look because when we discussed it, I think the last thing that we had said, I agreed to not go after child support, and so did she in the court. I wasn't even expecting to see anything from them. And so in the move, I never changed my address, and I understand that's my fault, and I do take responsibility. I should have been more thorough with that, but the other thing is they said that they're paying $600 for insurance for the children. They never told me they were going to put them on insurance. I have insurance for them and have had insurance for them. Still do through Medicaid, full coverage. I just checked 2 days ago.
Wait a minute, you got Medicaid, you say?
Yes, sir. Full coverage.
That's
Medicaid.
state assisted.
Sure.
I'm not going to have the state pay for it when there is insurance available through somebody else.
But I mean, they didn't even tell me that they were going to put them on insurance. I don't have a card. They never gave me any of the information that she was insuring them.
They can give you a card for it, ma'am. Why haven't you given him a card? Who's he insured through? Your husband or your work or what?
I have no idea.
Ma'am.
It's through my husband. It's through Davenport University.
And you provided all that information apparently to the friend of the court.
Mm-hmm.
And so all I'm asking you, sir, is no matter what I send to the friend of the court, it's going to come out the same. I mean, if you say, gee, I got insurance, I've got Medicaid, I'm not going to do that because that's the state of Michigan insuring him when there is insurance available. All right. Private. Second.
But I mean, but I could have at some point done the same thing and maybe later on when I wasn't doing so well and got insurance got child support from her. And I never did that because we agreed in court that once this is done, we're not going back and forth on this. And that's how I understood it.
Was there some court order? Because I have absolutely no recollection. I don't even know when you're talking about.
It was when, I don't know exactly the date either. And I'd have to get the transcripts on the court because when she forgave the child support, and she was saying, you know what, I can do this on my own. I don't need him to, I mean, we have half custody. $800 or $795 is absolutely bankrupting me. I have no way to pay for any of the kids' school stuff this year now. My other 3 are counting on me. This is going to destroy my family.
Wait a minute, you say your other 3, you have 3 other children, or are they your wife's children?
They're my wife's children. One of them is we completely have full custody of, and the other 2 we have half custody. And we work great with that with him.
You should be getting child support for those kids.
I'm sorry? They're
not your biological kids, right?
Correct.
Okay, then she should be getting child support for them. You're complaining that this is just the realities. Okay, I understand what you're saying, and I'm not an uncaring person. However, unless there's something that says specifically in an order that says, you know, child support is forgiven or something, the problem with it is child support it is for children. Okay. And so unless there is something that is I'm giving her the house, and she's getting an extra $25,000 in assets, we're going to apply that to child support and never going to get it. That's something that can be there. But basically the law says child support's always an issue. All right. It can't.
I mean, this is going to destroy. This is going to.
Turned around and she said, I don't need child support. So for a period of time, that's fine. I'm not gonna force it, but she filed, the friend of the court found legitimate, they got your income, they got it from your employer. You work for Morrow's Transfer,
Yes, sir.
and they got your income for, the 12
Well, I
months.
mean, this is gonna absolutely destroy my family. I'm gonna lose them because I'm not gonna be able to afford it, sir.
So-
This is unbelievable.
What is-
Unbelievable.
what
We
is
have
the-
half custody, and we agreed. Both of us agreed. There was times between now and the last time we did this that I could have said, "Hey, you know what? I'm not doing so well. I need some child support," and I never did that because I agreed to, just like she did to you or whomever it was, that this was it. We're not going back and forth. I can afford to pay for my kids when I have them, and she can afford to pay when she has them.
Ma'am, does he have, does he have 50-50, ma'am?
No. It's legally, it's supposed to be 50-50, but he does not take them 50% of the time. And that's all the information that I submitted to friend of the court as well for the income review.
And they have them pretty close.
But that's not true. That's not true. Her and I have worked where she's been like, "Hey, you know what? I could keep them another night, and if she needed me to, I would." But that's co-parenting. That's what this was supposed to be. In fact, last time we were in court, because she tried to take them from me just recently, and that was all came out to be that I was in the right, didn't do anything wrong. And
The ex parte order, the last time she got an ex parte from you, I dismissed it. That was last year in November.
Yes,
I dismissed the ex parte.
Yeah.
And
she
the friend
had,
of the court looked at it.
tax that.
The friend of the court looked
Can I
at it and
please
said
have
that
friend of the court look
you
at it
get
again?
approximately 164 overnights, so that's like 18 less than 50-50, is what they found. And that's the reality of it. And the income, you're not disputing the income.
Yeah, that was her working with me. That's not me. There was no custody change. There was no. I didn't get any paperwork saying that she has like over half custody, or I have more than her.
Listen to me. All
I
right?
don't understand.
Listen to me. There are many cases that I get all the time. I had one guy who came in who said, I got 50-50. The kids lived in Wisconsin. Okay. And when they made the order originally, he got 50-50. Then the family moved to Wisconsin. The guy saw him for like 2 weeks out of the year. I don't base child support based on 50-50. I based it on the actual overnights. I don't care what it says in there. And as of this point, I mean, you're within 18 overnights of exercising 50-50, if you will. They just found there was 164 overnights as opposed to 182 and a half. Hardly any difference. But
well, how many of those were during the ex parte that I wasn't able to see them, where she tried to pull that? I mean,
no idea.
Was that part of the 18 days? Well, I don't either.
No idea.
This is gonna destroy my life, Judge. This is it. It's gonna destroy my life.
Well, it's child support, and you unfortunately you're giving me,
I have to pay her way. She can't afford to support the kids.
Her income was reviewed. Your income was reviewed.
Can we please review it again?
For what?
Can you review it again, Judge?
For what?
So I'm able to put in some numbers here and put it and be involved in it.
What numbers are different than they used?
Well, they're using the $600 that they chose to put them on their own insurance without telling me or giving me any.
You don't have insurance for them.
We have Medicaid full coverage insurance, which is
telling
paid
you,
for by the state.
I'm not going to sit back and let the state of Michigan pay for kids when I can get private insurance.
Well, this isn't good for the kids because I'm going to lose my place I just got. There's no way I can afford this. Period. A period. That might now for the kids, they're not going to have a place to stay with me once I get evicted.
All right, ma'am.
And that's supposed to be helpful to the kids?
Ma'am,
how is that helpful?
It's child support. You got to have a deviation to make it change. Otherwise, it's through the computer, and it's not based on I can't afford it. It says this is what you can afford according to the calculations that are made way beyond me. I don't even do these. I have them. They come through on the computer. How much do you make? How much is insurance? How much is this? How much? boom, it spits it out. If you have to change it, I don't change it because I can't afford it. Because for all I know, you drive a Ferrari and you shouldn't spend that much money on a car. I don't know
I
anything
get
about your
Medicaid.
living
I get Medicaid.
situation.
I
It
definitely
says
do
that you
not
pay
drive the
first for
Ferrari.
child support and then you live off the rest. Ma'am, what is your response to any of this?
I'm sorry. I couldn't hear a lot of what you were saying because of what Stephen was saying.
Well, all I'm saying is it's child support and it's calculated through the state. Any response you have to this?
No, sir.
You think it's a correct amount?
Mm-hmm.
All right. I'm gonna send it to the friend of the court.
Yeah, well, she just got back from vacation,
Stop.
so
I'm
I
sending
can't
it
do
to
that.
stop.
I can't do that with.
Mute him. I'm gonna send it to the friend of the court. It doesn't change anything. The most it could change is from this day forward. It will not change what you owe up till this time. We'll send it to the friend of the court for a review. And even though I'm really loathing to do that because you basically admitted that you didn't look at your own mail so that you could respond to the friend of the court. I'm giving you a second bite of the apple, which you don't necessarily deserve. I'm gonna send it there for child support. Ma'am, what has been ordered is ordered up to this point. If it changes from this point, it will change from this point on.
Okay.
You better respond to your mail, sir. We're adjourned.
Thank you.
Both parties are present via Zoom. Mr. Arnson is here representing the defendant, Mr. Oakes. This was, I think, did mediation fail or something here?
Yes.
It did, Your Honor.
So
where are we at now, ma'am?
We went to mediation. Obviously, we could not come up with an agreement. I had, from my understanding, and I believe Mr. Oakes as well, we thought we were going for the friend of the court recommendation that day. And when we were told that it was just a mediation between the two of us, after that conversation, I had messaged Mr. Arnson to ask for clarification, asked if he could type up a recommendation, if we could go ahead and go through the front of the court for the recommendation. And he said that had
The
to come
recommendation of what?
we were supposed to go for a recommendation to see if custody, if there was factors in order to
You're
change
gonna try
custody.
and figure out, because he moved to Hesperia and the kids were
Correct.
in Cedar Springs, and you're gonna try and figure out something that would work for
Correct.
his family.
Yep. And Mr. Arnson told me that the order had to come through the court.
What order?
To go to the front of the court. I forget what it's called.
Where did you go to mediation?
Through the front of the court. But it was just the mediation between him and I, between Mr. Oakes and I.
Yeah.
So you had mentioned at the last hearing that we would go in front of the court for their recommendation to see if there was factors in place to change custody.
My understanding is you were going to mediation to try and work this thing out. That's what you do with mediation, okay?
Right.
And so why you can't work out anything?
I thought we were close. We've been going back and forth for a month and a half. On 7/31, Mr. Arnson informed me that Mr. Oakes was no longer willing to continue negotiations, and that was it. So now we're here.
All right. Mr. Arnson, how about you bring me up to date on your end of things?
Correct, Your Honor. We did, I had drafted an order from our last hearing here. I did send it to Ms. Behrens for review. I think there was some confusion as to, statements that the court makes in dicta as compared to what it orders. I did submit that order under the 7-day. I think it's actually going to be submitted today just to make sure we have that order. When we were here last, Your Honor, instructed the parties to go to mediation through front of the court.
Yeah.
There may have been some confusion by Ms. Behrens about whether that was for a review and recommendation or whether it was for mediation. The court did state to go to mediation through front of the court. If you couldn't resolve it, come back here. Your Honor, mediation didn't prove fruitful. The parties have been in negotiation. I did draft up a stipulated order with terms that Mr. Oakes agreed to. Those were not agreed by Ms. Behrens, so we're kind of back to square one. So, given all that's transpired here, Your Honor, I think the court has to send this to the front of the court for a custody, parenting time, and child support review and recommendation.
Well, so you stipulate to Vadvarka then for the court to look at custody. I mean, I don't even know if you can really stipulate to it. I got to find it no matter what, but
Your Honor, given my client's denial of parenting time and I think in conjunction with his move, I do think that the bargain is met. And I think I think the court was leaning that way, and I think the parties did try. There's a lot of disagreement between these folks, and I think the parties did try to resolve it, and they're just unable to.
But don't the parties have 50-50 right now, week on, week off?
They do.
And is that what's going on?
No.
No, Your Honor.
During the summer it would work, but what's going on with it?
From my client's perspective, Your Honor, Ms. Behrens continues to schedule things on the children's time, and he, contrary to language that was specifically in the judgment of divorce, and they can't even agree. The court was very specific about where the parties were going to meet last time, and they can't even agree on that. So he's been denied a lot of parenting time this summer, and
Has he filed any friend of the court complaints?
He did, specifically for the ones that were the parenting time that was held after back when the ex parte was denied. I think some of those might still be in process, but some of them were denied for not being timely.
How are kids are going to start school here pretty soon? They go to Cedar Springs?
They start August 21st.
They go to Cedar Springs?
Correct.
All right. And Mr. Aronson, how far does your client live from Cedar Springs? He lives in Hesperia or something?
Correct. It's about an hour away, I believe, maybe a little longer. He does work I think he works in Walker. So he drives that way for work anyway. And I believe the youngest child's homeschooled, the middle child goes to Cedar Springs, and the oldest child now goes to online schooling.
Correct.
So we've got only Aliana going to Cedar Springs.
Correct. She starts school at 7:40. Mr. Oaks informed us at mediation that he starts work at 6:45. And Walker is not anywhere near Cedar Springs.
Well, it doesn't matter whether Walker is whether or not he can transport the child there. But what makes you think he can pick the child up at the exact time that they get out of school each day?
I do the school pickup. According to the court order, Mr. Oaks is required to pick up the kids for school in the mornings, even on my weeks, and I'm required to pick the kids up after school, even on his weeks. The problem with that is he lives an hour and a half away from my house. So in order for him to get her to school at 7:40 to get my son here for homeschooling, the kids are going to have to wake up between 4 and 4:30 in the morning.
Have you always lived at the same spot, Ms. Behrens?
Yes.
All right. All right. I guess we're going to have some kind of hearing to figure out appropriate everything. Parenting time. I mean, the kids have got to go to school, right? And especially the child that's going to Cedar Springs. I want her to be there on time and go to school all day and get out. I don't know about Logan being online. He can do that from anywhere.
He is online, Your Honor, but the reason he was online that I pulled him into a different program is because he was failing at Cedar Springs. We were facing truancy charges because he was not going to school while he was living with Mr. Oaks. And his online program, although he can work independently, he does need guidance and kind of moving him along to make sure he's actually getting it done. He doesn't really work on his own. He does have questions. I do help him often with his work. So
Sounds like he should be going to school to me to learn that he's got to be able to do that. To be able to actually, he's got to learn that he can't work from home all the time necessarily. I'm not going to do that here. I think the only thing I can do is set up some type of a parenting time or custody type hearing to hear everybody out and make a decision on what the kids have to do. You kind of agree with that, don't you, Mr. Aronson?
I do, Your Honor. There's a lot of odd clauses in the judgment of divorce that I think hampered these folks.
Yeah, because they became unmanageable, and
to some degree, I think there should be some. I think the court could easily simplify this, and what happens on mom's time is that's what mom's time. What happens on dad's time, that's dad's time. Obviously, when you have a child who's homeschooled by Ms. Behrens, that makes it a little bit more difficult in that regard. But if the court wants to set up a hearing, that's fine. Otherwise, we would be fine if it went to front of the court for some type of parenting time and custody review. I'm not sure how a friend of the court could simplify some of these clauses in the underlying judgment of divorce, but I'll defer to the court on what the court wants to do.
Well, I'd like to send it to the friend of the court because this is just kind of all over the place. And yeah, I mean, it wasn't a very well, maybe it was a well thought out because at the time parties were going to do this way, but life changes a lot. And now it's unmanageable that he has to have a kid to her house for homeschooling at such and such a time. And he gets him back and he picks him up or she picks him up. And now they live an hour and 20 minutes apart, and some kids go to school and some kids don't. I guess I don't like to make a Vadvarka finding but if I don't, I can't really refer it to the friend of the court for custody. But the reality is the time is probably going to change enough between the parties that I need to look at custody also. So I'll make a Vadvarka finding that there've been a change of circumstances that have made the original judgment just plain unmanageable, and the original custody is unmanageable. Since the original order was send it to the friend of the court for custody, parenting time, ultimately child support, I guess. There's no reason to send it for legal custody, only physical custody.
I would agree, Your Honor.
For physical and parenting time, child support. In the meantime, you guys are gonna have to figure it out because that's not gonna happen overnight. Kids start school and all that kind of stuff. We're gonna have to figure out who's gonna transport and when. I want the kids to be fully involved in school and doing well in school no matter what. We'll
So
issue.
am I required to do all the driving then? Because that's what's happening right now.
For driving of what?
Everywhere, to and from school, to and from work, the activities that
How on
he is.
earth is he supposed to do it if he lives, the reason that you originally filed is he moved so far away.
I understand that, but according to the current order, that's what I'm trying to clarify. We
Yeah,
need
yeah,
some
you're
type
gonna
of
be doing all the
temporary
transportation to
clarification.
school when you've got him. If he's got him, he's responsible for it.
Okay, well, this weekend is his weekend. Our son works. We were supposed to go out of town, and Mr. Oaks is refusing to pick him up after work at 7:30 because he's going camping for the weekend. This has happened 3 other times
Because
since
who's
we came
going
before.
camping for the weekend?
Mr. Oaks is going camping for the weekend.
It's his
So
weekend.
I've canceled my weekend plans to pick up my son, even though it's Mr. Oaks' weekend. This is the 3rd time this has happened where I have to cancel my plans.
You guys can't figure out anything, all right? And if he violates his parenting time order, file with the friend of the court.
But he just doesn't pick him up. We scrambled 2 weekends ago because he was supposed to pick him up. I was out of town and Mr.
What are
Oaks
you
didn't pick
asking
him
me
up.
for? What am I supposed to
I
do?
guess I'm just.
You're asking me to micromanage your family and every decision that's being
The
made.
reason is because the last time we came before you, you said that if Mr. Oaks is unable to help with transportation, that Logan could stay here and I could take him. Mr. Oaks has taken that as he can go ahead and make plans whenever he wants, and I'm fully responsible, which leaves me not being able to take vacations or activities that are already planned on my weekends that I don't have the kids. I don't understand why if our son gets out at 7:30 tonight and doesn't work tomorrow, why Mr. Oaks is unable to pick him up.
And so what, if I say, Mr. Oaks, go pick him up, and he doesn't, what does that change?
I guess he doesn't have any accountability, and I will just continue
I'm
to take
asking
care of it.
you, what does it change? What are you asking for? I'm sending it to the friend of the court to try and get this whole thing worked out. If Mr. Oaks doesn't want to see his kid, I probably can't force him to, and it's foolish, and that'll come into play at a later time when I'm going to figure out custody, parenting time, and everything. If he's not going to be responsible for it, then trust me.
Then I will continue
I'll
to
find
do
that.
it.
Okay, but I can't do it on a Friday morning. I'm sending it to the friend of the court because you guys, I don't know whether or not you could agree that today's Friday.
Okay.
So I will deal with it appropriately. Any violations, anything that is inappropriate from you or him, I'm going to hear about it from the friend of the court. You're going to put it on in evidence here, and I'm not going to be real gentle with you guys because, quite frankly, I've seen you way too much, And
Well, in our back and forth mediation, he agreed to give me full custody. That was not part of the agreements that we were.
if you
we
didn't
couldn't-
agree to it, then it doesn't matter, okay? If it's a court order, all I can deal with is a court order. I can't, I mean, I have no idea what went on in mediation, nor is it appropriate for me to even find out, okay? It's not appropriate because you guys can talk about back and forth, and maybe he said, yeah, I'll give you custody if you do this and that, and you said, okay, so I got custody. I don't know that, nor do I want to know it. That's part of the mediation process, and the court's not supposed to know about it.
Thank you, Your Honor.
So, we'll send you to the front. It costs each of you $150 to go to the friend of the court for that. It will be paid and paid promptly. If the other person does not pay and the other one has to pay the full amount, I'm gonna take that into consideration too. But each of you pays $150 to the friend of the court. It will be done, and you better do it. All right. Mr. Arnson, I'm just gonna make the referral over there for it. I don't think there needs to be another order at this point.
Very good.
And we'll see everybody when, make sure you, get along with the front of the court and provide the stuff they need.
All right.
Thank you.
Thank you,
Good
Your
luck.
Honor.
Guess what time it is?
Number 9. This is the easy, number 9.
And
Number
it's
9.
only the defendant.
Yeah, because she's deceased. Why you're waiting for her to appear? Oh, my fault. Mr. Jackson, are you there? If you are, if you could unmute and turn on your camera for a minute.
Okay. 1 second. Yeah. Okay. Can you see me now, Judge?
Yes, I can. Mr. Jackson.
Okay.
I understand. I don't know who you'd serve with this motion. You indicated that Miss Hall is deceased. Is that correct?
Yes, she is, Judge. Yes, she is.
All right. And we would have brought you in sooner. My clerk didn't realize that, and she was waiting to see if the plaintiff was going to get on. Okay, because she didn't realize someone was deceased.
Okay.
So
Yeah.
I'm
Okay.
sorry you
Okay.
had to wait so long.
That's fine. That's fine.
You have 2 children. You have been found to be the father. You are the legal father
Yes.
of the kids. And Mr. Jackson has stated, has stated that unfortunately the plaintiff mother is deceased as of sometime in early July, and he's asking basically for a custody order.
Yes.
Is there, I mean, does anybody have a guardianship or anything on this?
No, not at all. No, not at all.
So the kids are living with you?
Yes, they're living with me.
All right. Let me tell you, I'll issue an order that just gives you full sole legal and physical, but you don't need it. All right.
Okay. I thought I needed it. That's why
You are the father. You are the father. And unless the only reason I'm going to send it out is in case school or something says, wait a minute, who, this kind of stuff.
Yeah.
You shouldn't have to because you're the father and you should be able to do anything you want with your kids. All right.
Okay.
And all I wanted to check was there is no guardianship. Nobody else has any claim to these kids. They're not adopted or anything like that. Okay.
Not at all, Judge.
So, I will send one out just so you have it, but you should not need it. You are the father. All right.
Okay. Yes. Okay. Yes, I did. I just on the safe side. So I said, I thought I'd go ahead, go to court and just,
Don't apologize because I understand what you're doing and everything. And you're dealing with a tough situation. I'm sure your girls are having a difficult time with this too.
Yes. Yes.
So I'm not faulting you. I'm not lecturing you. I'm just trying to tell you that, if anybody gives you grief about this, you just tell them I'm the father.
Right.
But I'm just going to send out an order that you have full sole legal and physical custody of the 2 children. That's Nyla and Layla.
Yes.
And we will get that out to you at your address. Don't tell me what your address is other than it's 1510. Is that correct?
Yes, it is.
We'll get it out to you in the next couple of days. All right.
Thank you.
Good luck
Yes.
to you. Thank you again. Sorry for the wait. There was just miscommunication with my clerk. Yeah,
Okay.
we'll get in and out of here right away. All right.
All right. Yeah, thank you.
Good luck. Thank you.
Yep.
Have a good day.
Yeah.
That's my fault. Oh, that's my fault. I should have told you early on that we weren't going to.
If you want, I can try to call them.
Yeah, good.
Hello? Can you
Hello,
hear me?
ma'am. Yeah, I can hear you. The defendant was on earlier and has logged off. I don't know if he's at work or whatever. We're gonna try and give him a quick call to see if he can log back on. It's his motion. So.
Okay.
We're just gonna give him a call to see if he can log on, because it's hard to grant him a motion if he isn't here to, and it's his motion that he's filed. Yeah, we apparently, hold on again, we're working on it here.
Telling you, again,
Okay.
This is, yeah, my weak point, this is the only weak point.
Right, bye-bye.
Worked a lot better when we called the correct number. He'll be logged in a minute.
No, he didn't get the text
You didn't get what text?
with all
Oh,
the information.
because
Because
it
it's the
was,
wrong number.
the clerk's office has the wrong number?
They did or I did it. I'm not reading it.
I think that's absurd because if I received the email and the text message, he should have received at least one.
He did, because he got on. Okay, he was on,
Yeah.
and then he logged off, probably, maybe he had to be at work, I don't know. Mr. Nickens, can you hear me?
Yep, I can hear you fine. Yeah, I have to go to work, so yeah.
All right, all
Yeah, we're
right.
good.
All right, this is case Cervera versus Nickens. Both parties are present via Zoom. This is Mr. Nickens' motion regarding ROPA. Says he's got two kids with Miss Cervera. Jonathan, in which there was a AOP, an affidavit of parentage from 9/15/22. There's also Ian, which apparently had a affidavit of parentage 10/3/21. He's asking for a paternity test because of new information that he says, at least as it relates to Jonathan. For some reason, he gave him a at-home DNA test and doesn't believe that he's now the father. There was a default judgment of support that was entered that made him basically the father also, or acknowledged him as that back in 23. He's within 3 years of birth, ma'am. Well, sir, that about tells me what you told me regarding Jonathan, correct?
That's correct.
And because you want an AOP or because you want a DNA test, you just also want one with Ian because there's nothing that you put in there that of misrepresentation or possible mistake of fact regarding Ian, but we'll deal with Jonathan first. Ma'am, what's your statement on this?
I have no statement. If he believes he's not the father, that's him. I did ask for the test results and never got no test results of it.
So you're all right with doing a DNA test?
Yes, sir.
Are you all right with doing a DNA test for both kids?
Yes, sir.
Then we'll order a DNA test on both children. And we'll wait for the results and see what happens.
Sounds good.
You're gonna have to, sir, unfortunately, I believe there's a cost and you're gonna have to bear it to begin with. If it comes back that you're not, then I'll reserve on that, okay?
Okay.
But because I wanna make sure it gets done. And you want it. So we'll send out an order requiring DNA testing, ma'am. Please make sure that the children get to the appropriate lab for DNA testing. All right. You'll get the order sometime next week, probably. So it'll be a few days till you get it, but then just get it done. Can't do a home DNA test because nobody knows. They got to make sure that they're gathering your DNA, sir.
Exactly.
Agree.
So
I agree.
It'll be
Perfectly
through a
fine.
professional DNA place, and we'll deal with it later then. All right.
Sounds good. Thank you.
Thank you. Have a good day, both of you.
Yep, you too. Man, shit.
And then now we're just waiting for the other attorney.
Actually, saw her.
And you've told Mary Gray that you actually see her. I mean, everybody's here now.
No, I said, I think she's logged into the wrong Zoom meeting ID because she's not on. She says she's logged in, but she's not on.
So you sent her a message? Did you send her our login number?
She can figure it out.
Don't mess with my clerk when plus she's not real good at numbers and not really sure that she can send the right numbers.
2 numbers off the clock.
Yeah. Search. All right. Welcome. Is it Miss Robrand? Is that how I pronounce it?
Yes, it is, Your Honor. Thank you.
I'll make sure.
I appreciate that.
Yes, Miss Slauson.
Good morning, Your Honor.
Good morning, everybody. We're here in case Streeter v. Streeter. We have both clients present with their respective attorneys. Miss Slauson for Mr. Streeter, Ms. Robrand for Miss Streeter. This is a simple motion to compel answers. Apparently interrogatories were sent to Mr. Streeter 6/7/24 with answers due early, I think it was 7/5/24. Requests were made to Ms. Slauson on 7/9, and I think, and on 7/19, there was a response that said they're on their way around 7/22. The parties have mediation set for 8/22/24. Ms. Robron, do you have the answers yet?
We do not, Your Honor.
Ms. Lawson?
Okay, let me start very back at the beginning. What she had filed was discovery motion that apparently was sent to me via email. I never received that. What I did receive from Ms. Robran was after forwarding my client's verified financial information form, I received a response from Ms. Robran stating a list of 9 items that she wanted sent to her after reviewing the financial information form. And those 9 items, it took quite a while, first of all, for my client to get the appraisal on his coin collection because we couldn't.
Do you have a set of interrogatories?
Well, what I did send her and what she has received was all those, but I never received her interrogatories via email. If I had, believe me, my client and I would have,
Ms. Robron, did you mail them to her or what?
We sent them via email, Your Honor, and we included the proof of service as Exhibit A.
It was only sent through email, right?
That is correct. That's how we've been primarily communicating.
And Ms. Slauson, there is a statement in here that says back on 7/19, they're on their way.
Right, and what I was referring to was her request for these, the documents that she sent me, a list of 9 documents. That's what I thought she was referring to this whole time. And I did send her those. She did receive all of those. I never got the discovery request. I got her request for the additional documents from the verified financial information form that we filled out and completed. You know, she wanted the actual, instead of him just saying what amount he received from his VA benefits or his pension, she wanted proof of what it was. So I sent her his bank statements showing this is what he receives each month from his pension. This is what he receives from Social Security. This is what he receives from his VA benefits. And then I sent 3 months worth of his IRA statements, his Ford Motor Company loan statements, the appraisal we finally were able to obtain on his coins, and his debit card statement. So we fulfilled what she.
The coin appraisal, I take it.
Pardon me?
As well as the coin appraisal?
We did receive that. It just took a while to get into this.
Yeah, but you sent that to the other party?
Yes.
Ms. Robron, help me out some. She says she sent, stuff to you that she got, and I don't know. Well, tell me what it is.
Yeah, understood, Your Honor. So initially, after reviewing Mr. Streeter's verified financial information form, there's significant holes, lack of statements. That is the email that Ms. Lawson is referring to, and that is the information that she did try to provide. She did not provide pension statements, Social Security statements, or VA statements. She just highlights where those deposits go into his account, but I have no further information from there. When we did not receive anything from that email, we followed up on June 7th with defendant's first set of discovery requests. What she recently sent me does not even come close to what we're looking for. There are significant issues in this case where we believe that plaintiff is moving money around, and we need those statements to determine where the money has been moved to, because what I see money being moved, but I don't have a complete picture because we don't have all the statements, so I can't follow the trail. And we have mediation on the 22nd in order to meaningfully participate and reach any sort of settlement negotiations. This is information that we do need.
Your Honor, may I respond?
Yeah.
Okay. A little history here. My client has a closed head injury from a car accident he received while in the military. He has been going downhill as far as his short-term memory. I do have statements from family members. I sent one of them to Ms. Robran explaining that as far as once I now have this discovery, which I did not have, we can go through this, but it's gonna take us quite a while to get.
When did you
It's
get?
24 pages of it.
And I'm sure some of it is simple and some of it isn't.
Right, and I just saw them yesterday for the first time, when she resent them to me. I said, why don't we postpone the mediation? There's not any great hurry here. And I don't understand why we can't do that. She said that the particular mediator that Ms. Robrand wanted was Mike Danema, and that he apparently can't do it until October. I have no problem going to a different mediator if in fact he can't mediate till the end of October. I'm sure Mary Benedict can do it in beginning of September, first or second week. There's
a bunch of people who probably can, whether it,
right,
this isn't a motion to adjourn mediation. You guys set it up anyhow, okay? So,
right. And I'd be happy to answer these discovery. It's gonna take time. It's my client, as I explained to Ms. Robrand, he has good days and bad days. He's here with us now.
I understand, but probably a lot of it is getting what, financial documents and stuff. Isn't that correct, Ms. Robrand?
Yes, it is, Your Honor.
I mean, good day or bad day, he just has to go to the bank and request it, or wherever it's from. Go to the.
And that is what he did, and that's what we sent to him.
And go to VA or whatever. I don't know where they're coming from. I don't know anything about this case other than discovery. And I don't, normally these are pretty easy. And my thought was he had to have them there and by the middle of next week. And probably attorney's fees, but now I'm getting this statement that says you didn't see him and now you do see him and you're gonna get him and all this kind of stuff. And Ms. Sloss,
there's no way I can get it done by
I've not known you to lie to the court before, so I'm not saying you're lying by that you didn't get him. And Ms. Robrand, you understand what I'm saying? I don't believe that she just plain threw him in a junk pile and didn't answer them. She's answered some of the stuff. What do you want? You want to get 14 days to answer those, but that goes out beyond your mediation, or if it doesn't, it gets you so close to it that it's not meaningful.
We would ask for the responses no later than August 15th, and then attorney's fees for $500, Your Honor.
I'm not going to grant attorney's fees, but I'm not going
to be able to do this by August 15th with my client, Your Honor. It's going to take a while. And also just I got 1 week's vacation per year. I'm supposed to be leaving this Sunday until the following Monday. We're going camping. I need time to sit with my client and explain what these questions mean. It's not an easy process. His comprehension is not. Okay. I don't want to be degrading here to anybody.
I understand. I'm not asking you to say anything more. Your point is.
I need more time.
Your point is not lost on me. And I'm thinking that probably between the two of you, you should be able to figure out, maybe you need to have your mediation 3 weeks later. I don't know. If Mike Dantema can't do it, then Mike Dantema, I'm not going to get into that. You guys need to mediate. You need to have all the information available to mediate. And so with
Can you give me till what is today's date? The 9th. If I could have, 2 or 3 weeks to sit with my client, because we're going to have to order all this. I'm going to have to do signed releases for this information.
This is what I'm going to require of you. All right. I also want you to show to Ms. Robrand that you are doing this. Okay. So if you're getting signed releases, I want her to know that it's happening. Okay. Because I'm going to give you some time to do it, but I'm not going to let you just sit on it. All right. So
and we won't, Your Honor.
So
we're not hiding anything.
I understand, and I'll take you at your word there. Vacation, I'm not going to destroy your vacation, anything. And that's going to take you out beyond your August 22nd mediation. It's not like you have a trial with Judge Hillary, because that wouldn't be adjourned, but you're going to mediation. I'll give you to the end of the month to answer the interrogatories or file appropriate objections, or at least make sure that Ms. Robrand is kept up to date. I want her to get her stuff, okay? And I want her to get it as soon as possible, so that because we also want to get this case over as soon as possible. All right, and I don't want to keep delaying it. Sorry, that's the best, we'll have till August 31st for answers.
Thank you, Your Honor. I
And,
appreciate
and,
it very
and
much.
again, I don't want, if Ms. Robrand comes back and says, well, I don't know whether or not she requested this stuff or not. Then I will whack you for attorney's fees, okay, and they'll be significant, all right, because I'll even do it for this one also. I'm not doing it right now because I want her to also be up to date on what you are doing, all right? I know you're gone for the next week, have a good vacation. I will be working, as will Ms. Robrand. We're all working while you're doing who knows what. So just remember that, okay?
I will. Thank you, Your Honor. I
Good luck,
appreciate it.
Ms. Robrand, it's just a difficult issue at this point. So
I understand, Your Honor. I appreciate your time. I will draft the order after.
thank you very much. I appreciate it. Everyone have a good weekend. Have a good vacation.
Thank you.
Take care.
Thank you.